Karyn's good question about.
Yeah, no, I think it's a great question. I think that probably what you would run into, first off, I think you were going down the path that she still has an absolute right to self-defense. So the question is whether or not she would have an obligation to retreat or not. That's the only part of stand your ground, and so that exemption that's written in there, that you have to be in lawful possession of the weapon, only applies to whether or not you have the duty to retreat if you retreat in complete safety. And so she's still afforded under current law, that wouldn't change anything. But the other thing is, I think that she is in lawful possession of that weapon because she has an absolute right to defend herself. And so it would be different if she has, a gun concealed carry on her, and she's 15 years old, and she goes to the park, and she is somebody is aggressive to her and attacks her. She would still have an absolute right to defend herself, but she would have an obligation to retreat because she's in unlawful possession of the weapon. So as long as your gun was legally there, and it was a tool that she could use to defend herself, she'd have the right to.
So I think that's kind of my thing is, all these bills have to be written to allow a layperson to read them and understand them. Because when we write a bill, our bill is designed for not the legislature, the bill, the people that the bill is going to apply to. So if we can't write one that is very easily understandable to the public, that's a problem. We need to make sure that if we're going to write one, everybody can understand it and everybody knows what their rights are within it. And I totally agree. We should not. The definition of reasonable retreat is so subjective. I mean, you don't know what I was feeling at the time, and a jury won't be able to determine that either.
Rob, one thing I'd like to say to that is, we are in a very unique situation. This is one reason why there's need to be more lawyers in the legislature, right? You guys need to be there. But we're in a unique situation where we are writing code, right? And so many words like reasonableness, everyone in here knows what it means. It means what a jury thinks it or a judge thinks. I mean, we deal with reasonableness all the time. So you've got to put it into here in the code. It's really hard to define reasonableness because we don't know of all the factors. So what it really becomes incumbent upon the legislature, and maybe, Karyn and I has failed in this, but we're working on it now. It's our job to go out and communicate to the layperson what the application, and to be honest and to be sincere so they can trust us, which is not easy to do as a lawyer and politician. But they have to trust us that is what it is. But you've got to write, when you're writing code, you got to write it in the code language of legalese. You want to try to make it as clear as possible. You don't want to confuse people where you don't have to confuse people. And we try to do that. Our code writers do that. But ultimately, we're writing it for lawyers, judges to interpret, and not for the general public to interpret. And I hate that. But ultimately, it becomes our responsibility as their representatives to help communicate to them. And frankly, the instructors out there and the law enforcement, all of us kind of have to try to help communicate what the code is.
Well, something too, I'll add is, we always talk about legislative intent, and every single meeting is recorded and is archived, so you can go back and look at it. I can't tell you how many times I've had to speak about the legislative intent of other legislation we've passed because no one knows what so-and-so means or how it's supposed to be implemented. And so I think that's really important to understand too. Even if it's not spelled out, sometimes people will go back and when you do the rules and promulgations, it's, well, what was the legislative intent? So that's important to keep in mind too.
I think again, it is written code. That's one of the reasons a lot of bills fail. Not just this one, but we have to be able to communicate to people, and sometimes it takes 2 or 3 sessions to not only write it correctly, but to educate the people. I think we made a huge error by excluding concealed license trainers now. We had an error in that bill, and I hope we can go back in the special session. We had the votes to bring that up so that we don't exclude people who have been training, having concealed carry licenses. Now we have the enhanced carry license. We kind of messed that up, and we excluded some people that should have been included and wrote it wrong. So again, it just takes a while sometimes to get it right, so we've got to go back and correct that. And I think we will, this session, be able to educate people as to what we're trying to do and what the bill does so that we can give people the freedoms they deserve.
Reverend, I think that's a good segue to ask you,